A political firestorm in Arizona has reached the Oklahoma state capitol. Oklahoma is among more than a dozen states, including Arizona, where legislation was introduced to allow businesses to refuse service to people on the basis of the business owner's religious beliefs. Consideration of the Arizona bill drew national attention over concerns it would encourage businesses to discriminate against customers based on sexual orientation. That debate affected similar legislation in Oklahoma.
Gay rights activists recently spent time at the state capitol visiting with lawmakers about issues of interest to the lesbian, gay, bisexual, and transgender community. Laura Belmonte is the chair of the Equality Network. Belmonte says one issue in particular attracted their attention this year.
A religious liberty bill modeled on the bill that just passed in Arizona that would allow someone to invoke their religious freedom as a pretext for discriminating against LGBT people.
The Arizona bill would have allowed businesses to refuse service to gays or other groups who offended their religious beliefs. Critics labeled it legalized discrimination. Numerous businesses, including the National Football League, expressed opposition to the bill, and Arizona's governor killed it.
Gay rights activists cheered today after Arizona Governor Jan Brewer vetoed a bill letting businesses refuse service to gays on religious grounds.
In her veto message, the Arizona governor rejected arguments by the bill's supporters who cited religious rights violations in other states.
Senate Bill 1062 does not address a specific or present concern related to religious liberty in Arizona. I have not heard of one example in Arizona where a business owner's religious liberty has been violated.
A similar bill in Oklahoma would have provided legal immunity to anyone who denies service to gays and lesbians based on the person's sincerely held religious belief. Representative Tom Newell is the author of House Bill 2873.
I think that if you're a private business owner, you ought to, just like the Hobby Lobby case now that's before the Supreme Court, that you don't somehow, just because you're competing in the marketplace, that you don't just have to put aside all of your religious convictions.
Newell still believes business owners should not be forced to serve someone if it violates their religious conscience, but decided to rewrite his bill after the Arizona controversy.
Even the Arizona bill got kind of a bad rap publicly, but again, that's just something that happens. It's a reality, and so we wanted to make sure that we didn't have those comparisons draw, and that our bill was a legally tight bill, so we just wanted to take the time to redraft that.
The language in the bill has now been replaced with a proposed new law designed to protect religious student associations on public university campuses.
This language is based on a couple of years ago in OU, the Christian Legal Society, a Christian group on campus. They required a statement of faith, of course, for their officers, and OU actually came in and threatened to remove their student organization status because they had that statement of faith requirement.
Newell says the issue was eventually resolved without legal action.
But this bill would just assure that in the future all our public universities would know that whether you're a Christian group or a Jewish group or a Muslim group, that you have a right of that freedom of association, and you can require those statements of faith, et cetera, for your individual organization and not be threatened with losing your status as a student organization.
Belmonte is glad to see the bill has been redrafted.
And we'll just have to be vigilant to ensure that it's not amended back to its original form. And in the event that it is, we'll be fighting very hard to secure its defeat.
The rewritten bill has passed the House Judiciary Committee, and Representative Newell expects it to be heard on the House floor next week.